We look at the justice system and see the preserved exterior facade of a constitutional republic. We see the marble pillars, the robes, and the formal courtrooms. But the actual exercise of power has quietly vacated these physical structures, migrating into a complex, self-sustaining administrative web. These failures, declining access, vanishing juries, and unadjudicated seizures, reflect a calculated structural design rather than symptoms of administrative neglect or a lack of funding. Under the Great Inversion, the government operates to secure the continuity, efficiency, and authority of its own administrative systems. The historical law of the land, requiring substantive constitutional restraint and strict lawful jurisdiction, has been displaced. In its place sits procedural fiat, where navigating the rules of an institution matters more than the constitutional limits of its power. This represents a massive, unwritten transfer of sovereign power. The American Republic has been operationally altered from the inside out without a single formal constitutional amendment. To understand the mechanism of this shift, we turn to the structural thesis of constitutional scholar Publius Custos regarding the Triple-Crown Coup. The driver of this condition is the integrated bar, a compulsory, judicially mandated professional guild that successfully embedded itself across the entire legal system. Traditionally, the Constitution mandates separated powers. Legislative, executive, and judicial branches exercise distinct delegated authority, flowing directly from the people. The integrated bar restructures this arrangement. A single professional guild infiltrates these branches, centralizing control. It severs direct accountability to the public, linking the branches into a unified administrative node. We will now trace the origin of this breach, map its current architecture, examine why it required the statistical death of the American jury, and reveal why the system is now structurally incapable of correcting itself. By embedding one professional guild with legislative, executive, and judicial authority simultaneously, the system converted a republic of limited powers into a self-ratifying administrative monopoly. We can pinpoint the structural catalyst for this modern consolidation. In June 1949, the Florida Supreme Court issued a decision formally integrating the state bar, creating a mandatory professional structure. This decision rests on a foundational constitutional defect. The court did not point to any constitutional text or a legislative enactment passed by the people's representatives. Instead, the judiciary claimed inherent power to create a mandatory professional guild. Inherent power has a precise historical meaning. It refers to original, self-existing sovereign authority. Under the American constitutional framework, inherent power belongs exclusively to the people. Institutions do not possess it. Government institutions exercise only delegated power. This is the strictly limited fiduciary authority granted to them by the public. A court has the authority to adjudicate specific controversies, but lacks the power to invent mandatory revenue-extracting institutions. The court's own documented rationale exposes the objective. The decision explicitly stated that integration was calculated to serve the best interests of the bar, rather than the constitutional rights of the public. This creates a direct constitutional contradiction, a judiciary using undelegated sovereign power to force citizens into a guild simply to access their own justice system. Firm. This 1949 fiat crossed the absolute boundary of the separation of powers. It morphed limited judicial adjudication into unauthorized legislative creation, sparking the structural breach that governs us today. This diagram maps exactly how the monopoly operates across the government, beginning with the first crown, judicial consolidation. Courts establish the monopoly by mandating guild membership as a non-negotiable prerequisite to participating in the justice system. Next is the second crown, legislative consolidation. Bar-affiliated committees draft the procedural and evidentiary rules, which the courts then adopt. This allows internally generated guild procedure to supersede substantive constitutional limits. Finally, the third crown, executive and financial consolidation. The integrated system operates as an executive enforcement body, disciplining its members and extracting massive revenue completely outside traditional jury adjudication. This financial extraction is highly measurable today. Through interest on lawyer trust accounts, known as IOLTA mandates, This structure generated approximately $279 million in revenue in a single year, redirected to court-associated programs. Beyond trust accounts, the system utilizes civil asset forfeiture. In Florida, state agencies retained more than $56 million in seized assets in a single reporting cycle, frequently without obtaining a criminal conviction. These financial structures alter institutional incentives. They transform the basic concept of professional regulation into an engine for direct institutional revenue generation. The Triple Crown effectively obliterates the separation of powers. It unifies the writing of the rules, the enforcement of the rules, and the financial benefit of the rules squarely within one interconnected professional framework. Historically, the jury functioned as an independent sovereign check on state power, a pre-political institution designed to distribute coercive authority back to the people. In the historic case, Georgia v. Brailsford, Chief Justice John Jay explicitly instructed the jury that they had the right to determine the facts and the absolute right to judge both the law and the government's actions in the controversy. That level of independent, unpredictable citizen judgment is intolerable to a centralized administrative system. Administrative governance requires absolute uniformity. Independent juries break that uniformity. The system relied on procedural suffocation to make the jury functionally obsolete, replacing it with administrative tribunals, summary dispositions, and negotiated pleas. This funnel visualizes the scale of the displacement. Nationally, between 98 and 99% of all criminal convictions completely bypass the constitutionally mandated jury trial. Look at the data flowing through that bypass. State-level records confirm the reality. Texas felony data revealed 471 guilty pleas for every 12 jury convictions. This ratio is driven by intense coercion. The system utilizes massive sentencing differentials and severe financial burdens, making the exercise of the right to a trial institutionally dangerous. This requires the structural alignment of the defense attorney. As a licensed member of the integrated bar, defense counsel is heavily incentivized by the Guild to prioritize negotiated administrative efficiency over uncompromising constitutional advocacy. The statistical death of the American jury represents a structural necessity, a deliberate neutralization of the only mechanism capable of interrupting administrative power. This chart reveals the closed loop of authority, a recursive trap. The institutions reviewing the rules are the same ones drafting and benefiting from them. This creates a jurisdictional impasse. A court cannot impartially rule on the legitimacy of structures upon which its own authority currently depends. To protect itself, the system uses the doctrine of standing as a weapon of containment. The ultimate reality of the great inversion is clear. The law of the land has been entirely superseded by an integrated professional monopoly operating well outside its constitutional boundaries. Under the firewall formula, the passage of time, repetition of precedent, and administrative convenience do not retroactively convert a usurpation into lawful delegated authority. As Thomas Paine established, all power is either delegated or assumed. All assumed power is usurpation, regardless of how long-standing it becomes. Time does not alter the nature of the act. Identifying this structural breach provides the diagnostic framework for restoring the constitutional order. We must locate the point of failure before demanding repair. Until the Triple-Crown consolidation is dismantled and authority is returned to its constitutionally delegated boundaries, true justice will remain practically out of reach.